Said, I am now going to turn it back over to our co-host from today, Maureen Reyes. Maureen, take it away.
Thank you, Jeff. Well, my name is Maureen Reyes. I serve as Vice President of Business Development for Akam here in Florida. We primarily been in business for over 40 years between New York and Florida. And we serve over 115 association mixed with condo and also HOA. We're a very tailored company, and I have the pleasure, obviously, of joining you. And that's it on my end. I mean, you could reach me, you have my email. I am here to help and serve the communities.
Well, thank you very much. And again,
Oh,
thank you for having
I
us.
forgot one thing, Jeff.
Yeah, go
One
for
thing.
it.
Tri-County, Broward, Miami-Dade, and Palm Beach. However, ACAM is growing significantly in Florida, so we're expanding. So absolutely, we could help in the Tampa area, Orlando, Jupiter. Feel free to reach out. That's it.
Sounds wonderful. Thank you for that. Thank you. I'm glad you remembered that as well. So right now we're going to turn it over to our instructor from the Tampa location, who will give a little bit more about herself, and then we'll get started with the presentation. I'd like to now introduce Kerstin Henze, the managing attorney of our Tampa location for Kaye Rembaum.
Thanks, Jeff. Thanks, Maureen. Lovely to be here with everyone. Thank you for taking time out of your busy schedules to join us this afternoon. My name is Kerstin Henze, like Jeff mentioned. I am a partner and managing attorney of the law firm of Kaye Rembaum. For those of you who are not familiar with the law firm, we are a community association law firm. So that means that we represent homeowners associations, condominium associations, and cooperatives throughout the state of Florida. Our main location is in South Florida in Pompano Beach, but we do have other locations in Palm Beach Gardens, in Orlando, and then on the West Coast, the office is located in Tampa. I've been practicing now for 17 years or so, and I have been with the firm since 2010. So I think I can say that I've been practicing in this area of the law my entire career, essentially. All right, so with that said, let's go ahead.
And that just means, by the way, we all started when we were 10 years old. I just want to throw that in there. Okay, just want to throw that in there. But Kerstin, back to you.
I don't like dating myself, but when I throw in, 17 years, oh man. All right, let me share. All right, can you see the slides?
Yes, now we can see them.
From the beginning. All right, here we go.
All set.
This party started. So this class, I just want to clarify, there is no requirement in the statute for this particular class to be 4 hours, okay? So that's a requirement for the condominium board certification classes. This class, we tend to do in about 2 hours. So that's the time you can expect to be here. And then I will stick around for a little bit after that to answer any additional questions that you might have. All right. So why are we here? Well, we're here because the legislature, amended the statute come July 1st of 2024 to provide some additional certification requirements. The obligation of new directors to attend an HOA board certification class has been in the books in the statute for some time. But some additional requirements were imposed this past legislative session. So within 90 days of being elected or appointed to the board of directors, each newly elected director has to complete an HOA board certification class. Now, that certification is valid for up to 4 years, provided that you serve uninterrupted. And then you have an obligation to complete the certification requirement at least every 4 years. Okay. Now, for those directors that were elected prior to July 1st of 2024, the position of the division has been that you have up to 4 years from the date of your election to complete this course. Okay, so just because you were elected prior to July 1st doesn't mean that you've complied with this, but you do have up to 4 years to complete this particular class. Now, the board certification class does have to include specific instruction, specific topics, areas that you need to learn. And those include financial literacy, transparency, record keeping, levying of fines, and then notice and meeting requirements. So everything that you'll be learning today is in compliance with the statutory requirements. Now, if a director does not timely file their certificate, right, you're going to get a certificate at the end of this class, and you will provide it to management if you're managed, or you'll provide it to your secretary who's in charge of maintaining your official records. And that certificate is going to stay as part of the official records. If you do not file your certificate, then you are effectively suspended from the board until you have complied with the requirement. Okay, and then the board can temporarily fill your vacancy during your period of suspension. Now, the certificates that you're going to get today, they have to be kept as part of your official records for at least 5 years. Okay, now the statute does say that the failure to have this certification on file with your official record will not affect the validity of any board action. Okay, so in addition to your board certification requirement, there are continuing education requirements, as Jeff mentioned. Now, the level or the amount of hours that you have to complete as part of your continuing education credit will depend on the size of your community. So if your community has fewer than 2,500 parcels, then you have to complete at least 4 additional hours of continuing education every year. Now, some classes are for 1 hour, some are for 2, so you'll have to, choose combination of those, but it has to equal at least 4 hours annually. If your community is comprised of 2,500 parcels or more, then your requirement bumps up to 8 hours of continuing education that you have to complete each year. Now, again, as Jeff mentioned, whether these continuing education classes start this year, the same year that you take your board certification class, or you have to start them next year, it's still unclear. The division is supposed to issue additional rules of clarification, and to our knowledge, they have not done that yet. Okay?
Come on, Kerstin. Everything they do is crystal clear 100% of the time, all the time. You know that.
Right? They keep us employed.
And I did interrupt with a purpose. I just want to mention to everybody, you're going to see me answering some questions for folks in the Q&A, and I'm only going to be answering non-attorney related questions. I do not have an ESQ after my name, as you know. So if it's technology related, or if it's something about the class in terms of certificates and that kind of a thing, I will answer it. If you don't see me answering questions that have to do with the course material, that is the reason why. Sorry for the interruption. Back to you.
All good. All right. We're going to talk about Chapter 720 of the Florida statute, which applies to HOAs, its purpose, application, and conflicts. All right. So in this slide, and by the way, you'll find that most of our slides have a lot of words, right? We find that it's more helpful to you board members to have actual complete sentences on these slides rather than just bullet points. I am not going to necessarily read through every slide verbatim. I will highlight certain things, but again, encourage you once you've, at some point after this class to go back and then, read through the slides when you have some time and opportunity to do so. Okay, So just some distinctions here in your slides between what an HOA is and what a condominium association is. And I know the word HOA is sometimes used interchangeably to mean condominium association and homeowners association. But for purposes of this class, whenever I say HOA, I mean homeowners association governed under Chapter 7 of the Florida statute. Condominium associations are governed under Chapter 718 of the Florida statute. They are similar in ways and very different in many other ways. Condominium associations are creatures of statutory law. That means that they are primarily governed by Chapter 718 of the Florida statute. Homeowners associations, they're more of a creature of common law. Common law is law that is developed in the court system by judges who ultimately make decisions. Another distinction is common areas versus common elements, right? Your community is comprised of lots that are owned by individuals, homeowners who buy in the community. And then areas that are outside of the lot will typically consist of common areas. HOAs do not have common elements. Common elements is a concept that is reserved for condominiums. You might also have come across a term called material alteration that refers to exterior changes to the common areas or common elements. Well, the term material alteration really is a concept in condominium associations. It's not really a concept for HOAs. What you will encounter for HOAs with regards to exterior changes to the common areas is you might find in your governing documents a requirement to get membership approval if the board is looking to expend association funds to change the common areas, okay? That's something that's going to be governed specifically in your governing documents, not so much in the Florida statute. Okay. Well, I mentioned that HOAs are governed by Chapter 720 of the Florida statute. Now, the question comes up is which version of Chapter 720 applies? And this has to do with a term called Kaufman language. In fact, I do a podcast on the last Tuesday of every month, and this was actually one of the questions that was raised by one of the listeners. What is Kaufman language? Well, Kaufman language refers to the magic words as amended from time to time that you might see referenced after reference to Chapter 720 of the Florida statute. And where you'll typically find Kaufman language is in the first page or two of your Declaration of Covenants. Okay. In your Declaration of Covenants, you might find language that says to the effect of, that this community is developed and is subject to Chapter 720, and then it might say as amended from time to time in the end. So if you have this language in your documents, what this means is that changes in the law, changes to Chapter 720 of the Florida statute will automatically apply to your community retroactively, okay? Now, there are two types of changes that legislature makes. They make substantive changes and they make procedural changes. In the next slide here, I included, the definitions of what are procedural and substantive laws. Substantive laws are laws that affect the vested rights of owners. So, for example, one of the changes that took effect July 1st is a restriction against a prohibition for associations under their governing documents. They no longer can prohibit commercial vehicles from parking in the community. Well, that's a substantive change because it affects the vested rights of owners. Whether that particular change in the statute applies to your community will depend if you have Kaufman. If you do, then you are subject to this requirement. And that means that if you have a restriction in your declaration that says no commercial vehicles allowed, you are not going to be able to enforce that provision. Okay, now if you do not have Kaufman language, then a constitutional argument that you can make is that the changes in the statute do not apply to you retroactively, which means that the law that applies is the law that was in effect at the time that the declaration was recorded. And this is based on a basic principle of the law that a legislature cannot make laws that retroactively impair existing contractual rights. Well, as you may know, your declaration of covenants is a contract between the association and the owners that buy into the community, right? And so the legislature can't just make laws that affect the covenants that are in that declaration. Okay, so if you don't have Kaufman, you could potentially raise the argument that the new changes in the law would not apply to your community. Now, procedural changes affect more of the procedure, how you operate. A typical procedure change would be a change to the statute that affects your election process. Doesn't affect the fundamental basic principles of the election, just the procedure, right? And so procedural changes in the statute will apply retroactively, regardless of whether or not you have Kaufman language. Okay, so if you have a question as to whether a specific change in the law applies to your community, then seek the advice of your legal counsel. All right, moving on. So in addition to Chapter 720 of the Florida statute, there is one other statute that applies to HOAs and really, you know, any community association, and that is Chapter 617 of the Florida statute. Chapter 617 of the Florida statute addresses or applies to not-for-profit corporations in the state of Florida. Well, as you may know, your association is a not-for-profit corporation. So when your community and association was created, the developer had to file articles of incorporation with the state of Florida, with the Division of Corporation. So you are governed under 617, which typically addresses more of the corporate structure of the entity. Who are the directors, who qualifies as directors, and so forth and so on. Generally, in the event of a conflict between the provisions of 617 and the provisions of Chapter 720, the provisions of Chapter 720 will apply over the provisions of 617. Okay. Now, we just talked about conflicts between different Florida statutes. What about conflict between your governing documents? Well, you have 3 documents that comprise your governing documents, right? We've talked about your declaration of covenants. Then there's articles of incorporation, and then there's bylaws. Your declaration of covenant is going to be your supreme document. Like I mentioned, it is the document that is essentially a contract between the owners that buy into the community and the association. It's the document that's going to contain your use restrictions, basically what you can and you cannot do. Can you have pets? Can you park commercial vehicles? Can you lease your home? Now, the articles of incorporation and the bylaws are documents that set forth the corporate structure of the entity, of the association. So it'll have things like who qualifies as a member, who qualifies as a director, who are your officers, how your elections are conducted, how you can fill vacancies, so forth and so on. Your articles of incorporation or bylaws should not contain any restrictions. Okay, I know boards sometimes use the word bylaws interchangeably with the word declaration to mean the declaration, but bylaws are a very separate and distinct document and should never contain your use restrictions. So if you have any use restrictions in your bylaws, speak to your legal counsel about amending your declaration to remove those restrictions and put them in the declaration. In the event of a conflict between any of these documents, your declaration is always going to be supreme. If there's a conflict between your articles and your bylaws, and a typical conflict could arise, for example, as to qualifications of directors. I get the question asked all the time. Well, does a director have to be a unit owner? But let's say your articles of incorporation are silent. That means that there's no restriction of who qualifies for the board. And let's say your bylaws specifically say that only homeowners qualify for a board seat. Well, there's a clear conflict there. And in the event of a conflict, your articles of incorporation are always going to control and prevail. Okay, so take a look at your articles. It's possible that you might need to amend, and so speak with your legal counsel about that. All right, let's move on to membership meetings. So first I want to kind of set the stage for meetings. In the overall big umbrella, there's going to be two types of meetings that you're going to have in your association. Okay, and you're not going to call it an association meeting. Okay, well, what is an association meeting? I don't know. It's either going to be a membership meeting or it's going to be a board of director meeting. Okay, so that is the big umbrella. Membership meeting or board of director meetings. Board of director meetings are meetings at which the board votes. A membership meeting is a meeting at which the owners vote. Okay, so with that in mind, we're going to discuss right now membership meetings. Now, under the umbrella of membership meetings, there's two types of membership meetings that you're going to have. There's an annual members meeting, okay? In the annual members meeting, typically it's if nothing else, it's the one and only membership meeting that you might have in your community. And it is the meeting at which directors get elected. Okay. Any other membership meeting that you're going to conduct other than your annual members meeting, it's going to be called a special members or special membership meeting. Okay. And you might call a special membership meeting for really any purpose for which owners need to vote on. So let's say, for example, you want to amend your governing documents. You want to amend your declaration. Okay. Owners get to vote on the amendments, right? They have to approve amendments. Well, unless you're going to present the issue at the annual membership meeting, you might have to call a special membership meeting for the owners to approve amendments. Okay, so that's what is referred to as a special membership meeting. Now, when is it called? Well, it's called, it can be called by the board of directors if there's an issue that the board wants to present to the owners for a vote, or it might be called if at least 10% of the total voting interest of the association petitions the board to call a special meeting, okay, for a particular purpose that owners need to vote on. Now, every meeting is going to include the date, the time, and then the location of the meeting. And then you will also need to include an agenda. You absolutely have to include an agenda for special membership meetings. For annual meetings, technically the statute doesn't require an agenda, but we recommend that you still include an agenda for your annual meeting, okay? And then an agenda is really, bullet points of all the issues that are going to go before the membership at which the owners are going to vote on. All right, so I already mentioned that all your meeting notices are going to include the date, the time, and the location of the meeting. And if the bylaws do not provide for procedure process for giving notice, then the association has to provide notice of membership meeting at least 14 days before the meeting. That's what the statute requires. Now, your notice can either be mailed, it can be hand delivered, or it can be electronically transmitted to any owner who has consented in writing to receiving notices electronic. We're not talking about electronic voting. We're talking about transmitting notices electronically, such as by email or by fax, okay? In order for you to be able to email official notices to an owner, and for that to constitute as the official notice to that owner, the owner has to consent in writing to receiving notices by email, okay? Now, if they do, email addresses do become part of the official records. Okay, and I just touched on this slide. All right, broadcast notice. So in addition to sending notice to the members in one of the ways that I just described, the board can adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda of a membership meeting on a closed circuit cable television system serving the association. For those communities that have a bulk service contract, this might be an option. If not, again, this is just an alternative method for providing notice to the membership. Now, website posting. Hopefully by now, everyone is aware that by January 1st of this year, for those communities that have 100 or more parcels, the association is required to have a website. Okay, so you should have already a website established by January of this year. Presuming that you've already complied with this, just be aware that you are required to also post notice of membership meetings on your website. So in addition to mailing or emailing or hand delivering the notice, you also have to post the notice on the website at least 14 days prior to the meeting. And then if there's any document that you've provided to the owners that's associated with the member vote, for example, if you're having owners vote on amendments and you've mailed them or provided them with a copy of the amendment, those amendments get to also be posted on the website at least 7 days prior to the meeting, okay? All right, members' right to participate. Yes, owners have the right to attend membership meetings and to speak at the meeting with reference to all items open for discussion, as well as all items included on the agenda. Now, the statute does say, regardless of what your governing documents say, an owner has the right to speak as to any of these items, either any items open for discussion or on the agenda for at least 3 minutes. And the board can also adopt reasonable rules governing the frequency, duration, and other manner of owner statements. So if you haven't adopted rules regarding owners' participation at meetings, then definitely encourage you to do that. Okay, quorum for HOAs, unless your bylaws provide for a lower number, quorum is going to be 30% of the total voting interest. Okay, so I have seen some older documents where there is a quorum requirement for majority of the voting interest. That would not apply. You would default to what the statute says, which is 30%, unless your bylaws provide a lower percentage. So if you have, for example, 10%, 15%, those are the other common ones I have seen, then quorum is the lower percentage. Now, unless otherwise required by law or the governing documents, decisions that require vote of the members must be made by at least a majority of the voting interest present in person or by proxy at a meeting. What this means is that, let's say you have a community of 100 parcels, to make it easier, right? And you've already established quorum, in this case, let's say 30%. So at least 30% of the owners are present at this meeting, either physically in person or by proxy. If 30 owners are there, a majority of the voting interest present in person or by proxy at a meeting in which a quorum has been attained means you would need a vote of a majority of the 30 owners who are physically there or by proxy. Obviously, if the number of owners present in person or by proxy is greater than your quorum, if let's say 40 people show up, then a majority of quorum would be a majority of those 40. So the more people show up, the higher that voting threshold will be. Okay, proxies. Unless otherwise provided in the statute or in your governing documents, members have the right to vote in person or by proxy. Now, it's very possible that your documents prohibit voting by proxy for owners. So you'll have to look at your bylaws to confirm that. As with any proxy, it has to be dated, include the date, time, and location of the meeting, and it has to be signed by the owner or the individual who is authorized to execute a proxy on behalf of the owner. Now, proxies are good or effective for 90 days from the date of the original meeting. So what that means is, let's say you are holding a membership meeting April 1st to approve amendments to your document. And let's say on April 1st, you didn't get the vote that you needed for the amendments to pass. There is a process under the law by which the board can recess and reconvene that meeting as many times as necessary up to that 90th day in order to get additional votes. Okay. If you're in this situation and you're looking just to learn about how you can recess and reconvene the meeting, speak with your legal counsel. Okay. Now, once that 90th day comes and you still haven't received the votes that you need, well, essentially the issue dies. You would have to adjourn the meeting and then you'll have to start the process again. Okay. There are two types of proxies, general proxies and limited proxies. General proxies, well, first, both can be used to establish quorum. The difference is that general proxy, typically you'll provide a general proxy, for example, with an election, just for purposes of establishing quorum. Limited proxies is what you're typically going to use if you need owners to vote on anything specific, such as amendments, or if you have statutory reserves and you want owners to waive reserves, and we'll talk about reserves in a moment, okay? Because the limited proxy will actually include what the proposal is. You know, vote on whether to approve amendment to Article 10 of the Declaration, yes or no, right? And then the owner will actually check off how he or she wants to vote, and then provide the proxy to the board, either by email, can mail it, can drop it off, or can give it to a neighbor to turn it in on the date of the meeting. All right, electronic voting. I'm not really going to talk too much in detail about electronic voting. I put here what the statutory requirements are. The big takeaway here is that if the board wants to institute electronic voting, it is a board decision. You don't need to get membership approval in order to institute electronic voting. And electronic voting means essentially hiring a platform, a third-party provider that has an electronic voting system. So owners who do not want to or are unable to attend a meeting can essentially log onto their computers and vote electronically. Okay, so really the first step is for the board to adopt a resolution to institute e-voting. That board meeting has to be noticed at least 14 days in advance. And the statute outlines what that resolution needs to establish. We've assisted many clients in instituting e-voting. It's a relatively easy process, and most boards have found it to be extremely helpful to boost not only attendance, but participation. Okay. Now, once the board adopts the resolution instituting e-voting, then owners, while they don't have to approve the process, they do have to consent to opt into the system. Okay. So only owners who consent in writing to vote electronically get to do so. Okay. Owners who do not opt in to vote electronically, well, then they'll have to vote the old-fashioned way, right? Either in person by ballot, or you'll have to provide them with a proxy in advance for them to fill it out and return it. Now, the statute does provide for certain requirements for that system. I've put them here. So the system has to be able to do certain things, right? Such as being able to authenticate the owner's identity. It has to be able to transmit receipt to each owner who casts a vote online, so forth and so on. So the requirements are here. So just make sure that when you seek out a vendor that, you know, an electronic voting provider, I'm sure they've complied with all of this, but you might just want to go through the checklist with them to make sure they're in compliance. All right. Elections. A vacancy on the board that's caused by the expiration of a director's term must be filled by election. Okay, so all director seats expire on the date of the election, and it's on the date of the election that you appoint directors to the board. Now, your election has to be held in conjunction with your annual meeting. Okay, so typically, if you have nothing else that you need members to vote on, typically the only thing you'll have in your annual meeting is your election of directors. Now, elections have to be conducted in accordance with the procedures set forth in your governing documents. So your bylaws should set out a process for you to conduct an election. And whatever that process looks like, that is how you have to conduct your elections. You don't get to choose and deviate from that process, okay? Because that will subject your election to legal challenge. I have seen, for example, boards that, decided they want to run their elections like condominiums, right? With the first notice and the second notice and the notice of intent to run, so forth and so on. And they've adopted that election process as a policy or a rule. That's not going to work, okay? You have to amend your bylaws to provide for the election process that you want to follow. Otherwise, you subject your election to a legal challenge. Unless otherwise provided in your governing documents, directors are elected by plurality of the votes cast. So it's not, whoever gets the majority of the votes, it's whoever gets the most votes that gets elected. Now, unless otherwise provided in the governing documents, a quorum of the members must be established in order to conduct an election. So the first agenda item for any annual membership meeting, and really for any membership meeting, is to establish quorum. If you do not have quorum, you cannot continue with your election or anything else on the agenda. Okay, what that means is if you don't have quorum and you can't conduct an election, then existing directors will essentially roll over for another term. Candidate eligibility. Well, the statute sets out certain eligibility requirements, and there are very few. So, for example, cannot be delinquent. So a person who is delinquent in the payment of any monetary obligation on the date that he or she could last nominate himself or herself cannot be listed on the ballot. So monetary obligation means not only assessments, but interest, administrative late fees, if the association can charge those fees, certainly any attorney's fees or costs. If fines have been imposed against an owner and they have not been paid, that is a delinquent monetary obligation that will disqualify the candidate. Person who has been convicted of a felony also cannot serve unless his or her civil rights have been restored at least 5 years. And then a person who has pending criminal charges for forgery of a ballot envelope or a voting certificate, felony theft or embezzlement offense involving association's funds or property, tampering with physical evidence, or obstruction of justice may not be elected to the board. Now, I have seen the bylaws of some associations impose other qualification requirements. The most common one is requiring that the director be physically present and in residence for a certain number of months out of the year. Because these are not statutory qualification requirements, if a candidate was disqualified on that residency qualification and that individual legally challenged your election, well, that individual might win. Okay, so just be aware that any additional qualification requirements could be subject to legal challenge. Nominations from the floor. So unlike condominium associations, the Chapter 720 of the Florida statute allows members to nominate themselves on the date of the election. The only way that you can dispense with nominations from the floor on the date of your annual meeting is if your governing documents provide for procedure for owners to nominate themselves in advance. Okay, if you have that procedure, and a very common one is similar to the nomination process for condominium associations, where owners who want to nominate themselves or run for the board essentially have to submit a notice of intent to run to the board at some point prior to the election. But again, that nomination process, right, has to be set forth in your bylaws for it to be valid. Okay, on the date of your annual meeting, on your election date, an election is not required unless you have more candidates. Then there are vacancies. If you don't need an election, then if you don't need an election, then essentially the directors or the candidates who submitted their notice of intent to run or who nominated themselves, they would just be seated by acclamation without the need of an election. Now, members have the right to vote in person or by proxy, right? But that's, if your bylaws authorize that. If your documents, if your bylaws permit voting by secret absentee ballot, and the bylaws have to expressly authorize that, well, then the statute says that the secret balloting has to be conducted very similar to how condominiums conduct their elections. So the election ballot would have to be inserted in what is known as an inner envelope, basically a blank envelope. That envelope is sealed and then has to be inserted in another envelope that is referred to as the outer envelope. And that outer envelope, the owner who just cast the vote has to include their name, sign their name, and then provide the parcel or the parcel address. Okay, so if you don't have that information in the outer envelope, then the ballot will be disqualified. And then unless otherwise provided in the bylaws, directors will serve a one-year term. Okay, election challenges. Any challenge to the election process has to be commenced within 60 days after the election results are announced. And election results are typically announced on the date of the annual meeting. So you have really 60 days from the date of the annual meeting within which to challenge the election process or the results. And the any election dispute can be submitted either to binding arbitration with the division of condominium, very similar to how condominium election disputes are handled, or they can also be filed in court. So those are the two ways by which you can challenge an election. All right, so members elect directors. The board elects officers or appoints officers. So officers are appointed by the board, and it's typically done immediately following the election of directors. Once you adjourn your annual meeting, you'll typically call what is known as an organizational meeting of the board. And really the sole purpose of that meeting is to organize officers, to determine who's going to be your president, your vice president, your treasurer director, or treasurer's secretary, and then you might also have additional officers. Now, directors cannot vote by proxy or by secret ballot at board meetings, with one exception. Directors can use secret ballots to elect officers. And by secret ballot, I mean you can literally have a post-it and have directors write the name of their selected officer on the post-it, and that could be the ballot. There's also no prohibition against changing officers midterm. So that means that if the treasurer is not doing what they're supposed to, and the board is not happy with the role of the treasurer, you can vote to remove that individual from their officer position, and you can appoint someone else as the treasurer. Now, if that treasurer is also director, just be aware that when you remove that individual from their officer position, you do not remove them from the board. They remain a director. The only way that a director gets to be removed is by a vote of the owners, right? Through the recall process. Now, a person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. These were some of the changes that were put into effect the last couple of years. So I'm not going to name them all, but essentially, for example, preventing a member from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change the ballot envelope, vote, or voting certificate. Okay, first-degree misdemeanor. So when you have a moment, just peruse these pages. What did go into effect July 1st is that each of the following acts also constitutes first-degree misdemeanor. These were added to the statute. Knowingly aiding, abetting, or advising a person in the commission of fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, or having knowledge of a fraudulent election voting activity, and giving any aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. All right, vacancies on the board. So unless otherwise provided in your bylaws, any vacancy on the board before the expiration of the term can be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum. So let's take an example. You have a board of directors consisting of 3 directors, right? And 2 directors have resigned. So you have one sole director on the board. Well, technically that sole director cannot carry out association business, right? Because you have less than a quorum on the board. The only thing that director can do at the moment is appoint enough seats to the board to constitute a quorum, so at least one other director. And then once you have quorum, then those directors can conduct association business. In the alternative, the board may hold an election to fill the vacancy, and you'll have to do the election in accordance with your governing documents. And then if there is a vacancy and that vacancy is filled, well, that newly appointed director will simply serve the rest of the term of the vacancy. All right. Moving on to board of directors. All right, officers and directors of an association have a fiduciary responsibility to the owners. That means they must act reasonably, right? And you're not expected to necessarily know everything, right? You're not experts in community association law, but you have to rely on the experts, right? You got to hire your legal counsel. You've got to hire your, property manager to assist with management. You might need an engineer, right? You might need an accountant. You will need an accountant. Okay, so hire your experts that you need to effectively run your association. Because remember, you are running a corporation. Okay, now the association's powers are exercised by the board. That means that no one board member should be making decisions for the rest of the board. Okay. One thing I did mention here, directors can use email as means of communications, but they cannot cast a vote via email. So yes, communication is acceptable, but you shouldn't be voting via email. You have to reserve the votes for a duly noticed board meeting. And don't run into a habit of having discussions via email and then essentially rubber stamping your decisions at a board meeting. Okay, that's not really going to work, because owners will just think that you guys are conducting business behind closed doors. Okay. All right, board meetings. Remember, board meetings are meetings at which the board gets to vote on things, right? Such as, contracts. If the board is looking to hire a contractor, the board gets to vote on it, right? The board is the one that adopts the budget. So most functions of the association are carried out by a board vote, not owner vote. So as with any meeting, board meeting notices, they have to include the date, time, and location of the meeting, as well as all agenda items. Now, typically, board meeting notices only have to be posted at least 48 hours prior to the meeting, unless there's an emergency. Now, if your governing documents require for more notice, then you go with what your bylaws provide. There are two types of meetings under the statute that do require 14-day notice, unless, of course, your bylaws provide for a greater notice requirement. Otherwise, notices of meetings at which the board's going to adopt a special assessment, or notice of meetings at which the board is going to adopt a rule that that affects parcel use. For example, if you're going to adopt architectural standards or specifications for homes, right, that affects the parcel. And so notice of that meeting has to be mailed, hand delivered, or electronically transmitted at least 14 days prior to the meeting. And then you also have to post notice of that meeting as well, 14 days in advance. Remember your website posting requirements, right? So notices also have to be posted on your website. Okay, this law went into effect July 1st. And again, you should have complied by January 1st of this year if you have 100 parcels or more. All right, member participation at board meetings. All meetings of the board must be open to all members, except there's two types of meetings that do not have to be open to the members. There are meetings between the board and legal counsel with regard to any pending litigation or proposed litigation. And then any meeting held for purposes of discussing personnel matters. Now, you're still going to notice the meeting, right? You're going to include note on the notice the date, time, location of the meeting. You're also, however, going to put, meeting closed between board and legal counsel, or closed meeting for purpose of discussing personnel matters. Okay, that's it. Now, members have the right to attend all board meetings, as well as the right to speak as to any agenda item. Now, there's nothing in the statute that says that owners get to speak at least 3 minutes at these board meetings. Okay, but if you adopt a rule that at least allows owners to speak 3 minutes, that will likely be considered reasonable if challenged in court, given that owners get to speak at least 3 minutes at membership meetings. So if you haven't adopted rules regarding owner participation at meetings, membership, or board, I encourage you to do so. Any owner can tape record or videotape board meetings. And board meetings must also be held at a location accessible to physically handicapped persons if it is requested by physically handicapped person. Now, a director, officer, committee member may not directly receive any salary or any compensation for performing their duties as a director or officer, except, and these are all in the statute in Chapter 720, Participation by such person in financial benefit accruing to all or significant number of members as a result of actions lawfully taken, or reimbursement for out-of-pocket expenses incurred on behalf of the association, so director officers can be reimbursed, or recovery of insurance proceeds, or if the fee or compensation is either authorized in the governing documents or approved by a majority of the voting interest. Otherwise, no compensation or fee. Kickbacks. An officer, director, or manager cannot solicit, offer to accept, or accept a kickback. And a kickback has not been defined in the statute, which is anything or service of value for which consideration has not been provided to an officer, director, or manager's benefit or the benefit of their family members from any person providing or proposing to provide goods or services to the association. And it is a third-degree felony if an officer, director, or manager knowingly violates this prohibition. And they have to also be immediately removed from office. However, an officer, director, or manager can accept food to be consumed at business meeting with a value of less than $25 per individual, and as well can accept service or goods received in connection with trade fairs or education programs. So many of you have probably attended these HOA condo expos or trade shows where you have vendors with their booths and they have trinkets and goodies, and you walk around and you meet vendors and they'll, you know, what is that? Exactly. We've certainly, you know, Kaye and Rembaum certainly attends these trade shows, expos. In fact, we teach classes at these trade shows. Well, you can breathe easily, you can accept these goods, you can have lunch at the trade show, and that is not a kickback or a violation of the statute. Now, a director or officer charged by information or indictment with any of the following crimes must be removed from office. Okay, and I've listed them here. So there's been a big shift in the last few years in the statute in criminalizing certain types of conduct. And then the board must fill the vacancy until the end of the period of the suspension or end of the director's term, whichever occurs first. However, if the charges are resolved without a finding of guilt, or without acceptance of a plea of guilty, the director or officer must be reinstated for any remainder of his term. Another ground for immediate removal, well, if a director becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association, they're deemed to automatically have abandoned their seat. You don't need to have a board meeting to officially remove this director because of delinquency. The statute already says they're deemed to have automatically abandoned their seat. All right, conflict of interest disclosure. So directors and officers have to disclose to the association any activity that can be reasonably construed to be a conflict of interest at least 14 days before voting on the issue. Now, the statute says that there's a rebuttable presumption of a conflict of interest if these two things occur. Either the director, officer, or a relative of a director or officer enters into a contract with the association to provide goods or services, or the director, officer, or relative of a director or officer has an interest in an entity that is looking to enter into a contract with the association. Now, the statute doesn't per se prohibit these types of contracts or transactions, but it does lay out a process by which the board has to approve these transactions, and you have to comply with them. So the proposed contract has to be disclosed at a board meeting. The disclosure has to be entered in the minutes, And then 2/3 of the directors who are present have to approve that contract that is subject to a conflict of interest. Obviously, the contract with the director officer has to be reasonable and fair. And then the final step, which is what most boards forget or neglect, is at the next regular or special membership meeting, you have to disclose to the membership this contract or transaction that is subject to conflict of interest. And then the membership can, by a vote of a majority of the members, cancel that contract. So board can approve it, but the members always have the right to cancel that contract. And if the membership votes to cancel that contract, well, you'll have to terminate the contract, and the association would not be liable for any penalties of cancellation or liquidated damages for terminating the contract early. You would just be responsible for the cost of services provided through the date of termination. All right, let's move on to official records. We're about 1 hour in. All right, in the next few slides, I've identified here all the documents that the statute says constitute your official records. I'm not going to read them here, but they're here for you to take a look after the class. And essentially, you know, it consists of your governing documents, it consists of contracts, bids, so forth and so on. Now, all official records have to be maintained for at least 7 years, unless, of course, your documents provide for a longer period. There are several exceptions to the 7-year requirement, and those are for bids. Bids received by the association have to be only be kept for 1 year. And then let me go back to this slide. The third bullet point from the bottom, where it says ballots, sign-in sheets, voting proxies, and all other papers or electronic records relating to voting by owner. So any document related to a membership vote, those only have to be kept for at least 1 year. Everything else, 7 years. And then effective July 1st, the association has to adopt written rules governing the method or policy by which the official records are to be retained. Now, the official records of the association are accessible to members with a few exceptions. And I've listed here what those exceptions are. And these come straight from the statute. So, records protected by attorney-client privilege, any legal opinions from your legal counsel, technically protected. Any information obtained in connection with the approval of a lease, of a sale, or other transfer of parcel, that's also not accessible. So if your community has the ability to approve or disapprove sales or leases or any other type of occupancy, those records have to be kept confidential. So if you obtained a background report, a criminal background report, or a credit report on an applicant, you cannot disclose that. In fact, that's a violation of Fair Debt Collection Practices Act. Any information obtained in a gated community in connection with guest visitors to owners or residents, and then certainly social security number, driver's license numbers, fax numbers, email addresses, unless the owner has consented to disclosing this information. Some additional records that are not accessible to members, including personnel records, medical records. Medical records might come into play if you have a situation where an owner is requesting an accommodation under Fair Housing Act. Attorney-client privilege information, just note that only the board can waive attorney-client privilege. Okay, so you know, if your legal counsel has provided a legal opinion on an issue, right, that's privileged. If the board then wants to go ahead and share that legal opinion with the member, or the rest of the membership, that is a business decision of the board. Only the board with its privilege. Okay. Membership directories. An association may print and distribute to owners a directory containing the name, lot address, and telephone numbers. But owners may exclude their telephone numbers from the directory if requested in writing. And then certainly any owner can also provide written consent to the disclosure of other contact information, such as email addresses. Now, access to official records. So the next few slides have to do with owners who submit a request to inspect the official records of the association. So unless otherwise provided by law in your governing documents, the official records must be made available for inspection within 45 miles of the community or within the county. And then they have to be made available within 10 business days after you received a written request. Now, the statute does say that if the request is submitted by certified mail, right, then there's a rebuttable presumption that the association willfully failed to comply if you do not provide access to records within 10 business days of receiving the request by certified mail. That does not mean that the request has to be submitted by certified mail. It's just that if it is, there's a rebuttable presumption that you willfully fail to comply if you don't timely provide the records. So what that means is if you do receive a request to inspect association records and it's not sent by certified mail, still comply and provide records within 10 business days. If you don't provide access to records within the statutory timeframe, then the owner can claim damages. And the minimum damages are $50 per calendar day up to 10 days. And the calculation begins on the 11th business day after receipt of the written request. Now, another law that took effect July 1st is that if an association now receives a subpoena for records from law enforcement, the association has to provide a copy and make these records available within 5 business days of receipt of the subpoena. The association also has to now assist a law enforcement agency in investigation to the extent permissible by law. Now, the law was also changed, became effective July 1st, that criminalizes now certain conduct as it relates to access to official records. So, effective July 1st, if any director or manager knowingly, willfully, or repeatedly, and the term repeatedly is defined as 2 or more violations in a 12-month period. If you knowingly, willfully, or repeatedly fail to provide access to the official records with intent of causing harm to the association and one of its members, you commit a second-degree misdemeanor. Any person who knowingly and intentionally defaces or destroys accounting records, or who knowingly or intentionally fails to create or maintain accounting records, which you're required to maintain, with the intent of causing harm to the association, also commits a first-degree misdemeanor. And then any person who willfully or knowingly refuses to release or produce association records with the intent to avoid or escape detection, arrest, trial, or punishment commits a third-degree felony. So obviously this does not pertain in the event a director, was negligent and missed the deadline, right? There has to be an intentional act, knowing, willful, and certainly repeated. Okay, an association, and the statute allows for an association to adopt reasonable rules governing the frequency, time, location, notice of records, inspections. Okay, and if you don't have any, certainly encourage you to do that. It will make it easier and will streamline the inspection process, especially if you have owners in your community that are constantly making these official records inspections requests. Now, The statute does say that while you can adopt reasonable rules, the association cannot require an owner to show any purpose for the inspection or require the owner to state a reason for the inspection. So an owner is entitled to inspect official records regardless of what their reason or purpose is. You can't require the owner to state that reason or purpose. And you also cannot limit an owner's right to inspect records to less than 8-hour business days per month. Okay, anything less than that, if an owner legally challenges it, well, you could lose. All right, copying records and fees. So if an owner shows up at the records inspection with a portable device, smartphone, a tablet, an iPad, a portable scanner, and starts taking pictures of the records, that is acceptable, and you cannot charge the owner a fee for making these for making copies of these records in this fashion. Now, if the owner wants you to make photocopies of certain records, if the association has a photocopy machine available, then it has to provide the owners with copies on request during the inspection if the request is limited to no more than 25 pages. Okay. Now, if the association can charge up to 25 cents per page if you're making photocopies on an association copy machine. If you don't have a copy machine and you have to make if you have to make copies, by an outside vendor like Kinko's, and the request exceeds 25 pages in length, then the association can have the copies made and charge the actual cost of copying, which has to be supported by the vendor invoice. Now, the association can also charge for the cost required for any personnel to retrieve and copy the records if the time spent retrieving or copying the records exceeds 1/2 hour, and if the personnel costs do not exceed $20 per hour. You cannot charge personnel costs for records requests that result in copying of 25 or fewer pages. All right, quickly moving on to association websites. I've already mentioned this several times, but I've included here more specific requirements for your website if you still have not complied. Hopefully you have. Again, if you have 100 or more parcels, you needed to have already established a website by January 1st. Upon request of any owner, the association has to provide the owner with a username and password to access protected information. And I've outlined here also the types of records that have to be posted. You don't have to post everything. I've outlined exactly what you need to post, including budgets, governing documents, contracts, and notices of meetings, as I've mentioned. All right. Let's quickly talk about amending governing documents. Now, I do teach a separate webinar on just amending the governing documents, so I'm not really going to speak at length here. Just want to highlight a few things. If you are looking to amend your governing documents, unless your documents provide otherwise, you need the approval of 2/3 of the voting interest. Certainly, if you have a high threshold, such as 75%, you might want to look to first amend your documents to lower the threshold before you provide to the owners a substantive amendment for them to vote on. Any changes that you make to the documents have to be demarcated with either underlines if you're adding, and then strike throughs. You got to put a strike through any language that you are crossing out. There's an alternative to that. If you're doing substantial amendments, then you have an option to make the changes without redlining, without including the underlines and strike throughs, but then you have to add language here that's in the second bullet point that says substantial rewarding, see governing documents for current text. Obviously, the drawback of doing it this way is that the owner's not going to see what words were changed. So they'll have to, take the amendment and then compare it with the original document. For some communities, that might not be very helpful. In fact, you might not even get the support if you present it this way. So, speak with your legal counsel about which option is more beneficial for your community when presenting amendments. It's very possible that your governing documents might also require you to obtain the consent of mortgagees, those lenders that have a mortgage on the individual parcels. If you do, there is a statutory process for getting mortgagee consent. So speak with your legal counsel about that. Any amendment to your governing documents is going to be effective upon being recorded in the public records. So make sure that once an amendment passes, it also gets recorded. And then the statute does provide a requirement that once you have recorded an amendment, you do have to provide either a copy of the recorded amendment or notice to the membership that the amendment has been recorded, and it would be made available to the owner upon their request, free of charge. All right. So a few gems all board members should know. So in the next few slides, just want to highlight just a few other things just for you to be aware. Hopefully you are already. And so this is then just a, just a review. Okay, so we've talked about the association being a corporation, not for profit, right? Okay, so with that comes 2 filings that you're going to do every year. To maintain active corporate status, you have to every year submit or file an updated annual report with the Division of Corporation. And that the website, I believe, is sunbiz.org. And it's a very easy process. Typically, your manager does that for you annually. And that report has to be filed between January and May of every year. There is a small filing fee. If you file your annual report after the deadline, there is a penalty, a few $100s. Okay, so make sure you timely file a report. And typically you'll file the report after you already had your annual meeting, because on that report, you're going to update who your directors and officers are. You also have an annual income tax that you have to file. So while the association is a not-for-profit corporation, you're not exempt from filing annual tax returns. So make sure that you have a CPA, an accountant that assists with that. Meeting minutes. So all meetings have to have minutes, right? Minutes, however, do not need to be a verbatim record. So I have seen where board members, have these minutes that go on for pages and pages of everything that was discussed, everybody who made a comment. That is not what minutes are intended to be. Minutes have to be a short record of what took place. So at a minimum, it needs to include who attended the meeting, which directors, the motions that were made, who made the motion, who seconded the motion, and what was the vote. Depending on the issue, if it's a very controversial issue, you could include, a little synopsis of maybe what was discussed, but that's about it. It is not intended to be a transcript of everything that took place at the meeting, right? That could potentially expose the association to a legal challenge. Rules and regulations. Typically, the board of directors adopts rules, provided you have the authority to do so in your governing documents. Now, I have seen governing documents that provide that rules have to also be approved by the owners. So don't just assume that the board gets to adopt rules. Take a look at your governing documents and see what authority you have for adopting rules. Typically, if you're going to adopt rules concerning, common areas or general association operations, that only requires notice of a meeting to be posted 48 hours prior to the meeting. If, however, you're adopting rules specifically affecting parcel use, the statute says unless your documents provide otherwise, you have to provide 14-day notice of that particular meeting. And then with any rule that you adopt, you have to, after you adopt the rule, provide a copy of the rules to all the owners for those rules to become effective, right? Owners have to be aware of what the new rules are. Okay, Marketable Record Title Act. This is a very complicated area of the law, and there's just not enough time to specifically talk about this. The big takeaway here is that you need to be aware that your governing documents, your declaration of covenants, is only good for 30 years after the initial recording of the declaration. And I'm simplifying the concept here. But please, if this applies to you, call your attorney right away after you get off this certification class. Your documents, again, are only good for 30 years from the date of the original recording of your declaration. That means that if you are getting close to those documents expiring, under the law, you have to take certain action, okay, and record certain documents in the public records in order to extend the life of these documents, in order to preserve these documents for another 30 years. That process typically only requires a board vote. If you've missed the deadline, okay, so if your documents have already expired, if you go and you pull your declaration and they've already expired and there's nothing recorded in the public records that preserves these documents before they expire, then essentially you have no way of enforcing any of those documents, right? Which could even affect your ability to collect assessments. There is a process under the law by which you can revitalize these documents. However, that process requires a membership vote. And then once you get a membership vote, you also have to get approval from the Department of Commerce in the state of Florida. So it is a much more, not so much complicated, but it's certainly a lot more hoops that you need to follow if your documents have expired, and certainly a much more expensive process. So take a look, be aware, and make sure you have a plan in place to preserve your documents before they expire. If they've already expired, definitely contact your legal counsel to discuss the process of revitalization. All right. The next few slides deal with emergency powers. I'm not going to even touch on it. Certainly emergency powers were invoked during COVID. And after COVID, the legislature made some changes to the statute. So just be aware of these emergency powers and how you can use them in the event of next emergency, for example, a hurricane. Okay, so I'll leave the slides. I'll go through these slides. Okay. Litigation authority. Certainly the association can be sued as an entity, and the association can also sue, whether it's owners or other entities or individuals like, contractors. Just know this limitation in the statute, that before commencing litigation against any party in the name of the association involving amounts of controversy in excess of 100,000, the association has to obtain the affirmative approval of a majority of the voting interest. Okay. All right, architectural control. A lot of the changes that took effect July 1st have to do with architectural standards and control for HOAs. So the next few slides, we've added them here. We also do a legal update webinar where we talk about all the new changes in the law and touch a little bit more in detail on these. But effective July 1st, The association must now reasonably and equitably apply and enforce all architectural standards. That seems very logical, right? But now it's codified in the statute. And then, importantly, if you have the ability to approve or disapprove architectural changes to the exterior of homes, right, and the association denies an owner's request, the association now has to provide written notice to the owner stating with specificity the rule or covenant on which the association relied when denying the request, as well as the specific aspect or part of the proposed improvement that did not conform to the rule or covenant. So I have seen where boards have a very standard, architectural request form where the owner fills out what they're looking to change, and then at the bottom of the form, they might have a space for the owner to check off approve or disapprove, right? And if you disapprove, you check it off and you send it back to the owner. That will no longer suffice. You have to provide specifics as to your authority to disapprove and what part of this architectural request does not conform with your existing standards. Also effective July 1st, the association cannot enforce or adopt a covenant, rule, or guideline that limits or places requirements on the interior of a structure that is not visible from the parcel's frontage or an adjacent parcel or adjacent common area or community golf course. So for most HOAs, if you have single family lots, this is not a problem. Right? If an owner wants to update their kitchen, it's inside. You can't see it from the outside. You can't request an owner to submit an architectural request form for approval. If you are in an HOA that operates townhomes, right, this is going to be potentially a little bit more problematic if an owner wants to do some kind of alteration inside that could potentially affect, a boundary wall that is shared with another townhome. Right? But this is the current state of the law at the moment. You also cannot require review and approval of plans or specifications for a central air conditioning, refrigeration, heating, and ventilation system if the system is not visible from the frontage, adjacent parcel, or adjacent common area or community golf course, and is substantially similar to a system that is approved or recommended by the association. Now, this section of the statute, it has been in the books for a couple of years now, but it was amended effective July 1st to include the language in blue. So essentially, regardless of any covenants or restrictions in your governing document, unless it's prohibited by law, an association cannot restrict an owner from installing, displaying, or storing any item on the parcel which is not visible from the frontage, adjacent parcel, or an adjacent common area or community golf course. And that includes, but not limited to, artificial turf, boats, flags, vegetable gardens, clotheslines, or recreational vehicles. Also, effective July 1st, this applies to all HOAs, regardless of the date that you created, regardless of whether or not you have Kaufman language. Remember we talked about Kaufman earlier on, as amended from time to time. Regardless of whether you have this applies to all communities, HOA communities in the state of Florida. You have to adopt hurricane protection specifications for each structure or improvement on the parcel governed by the association. Now, hurricane protection is defined in the statute, includes but is not limited to roof systems, storm shutters, impact resistant windows. Okay. Once you adopt specifications, they have to comply with applicable building codes. Right? And then any specifications can include the color and the style of the hurricane protection, or any other factors deemed relevant to the board. And then once you adopt these specifications, you cannot deny an application for installation, enhancement, or replacement of the hurricane protection by an owner which conforms to these specs. Vehicle restrictions, right? This has been the source of a lot of contention here with HOAs. Effective July 1st, an association cannot prohibit. So if you have restrictions, any restrictions affecting any of these types of vehicles in your existing governing documents, right? Your governing documents, right? You cannot enforce those restrictions. You cannot prohibit an owner, tenant, guest, or invitee from parking their personal vehicle, including a pickup truck, on the owner's driveway or any other area which the owner, tenant, guest, or invitee has the right to park. You also cannot prohibit the parking of a work vehicle, regardless of any official insignia or visible designation, which is not a commercial vehicle as defined in section 320.01, subsection 25 of the Florida statute. So I can tell you that a commercial vehicle, the way that it's defined in the statute, is essentially a vehicle that weighs 26,001 pounds. That is the definition of commercial vehicle. So unless the vehicle that is parking your community weighs 26,001 pounds, right? If we're talking about Joe's plumbing truck that has signage on the exterior or has visible, equipment, materials, whatnot, you cannot prohibit Joe's plumbing truck from parking in your community. But remember, we talked about Kaufman, and we also talked about the retroactive applicability of changes in the statute. So whether or not these specific restrictions apply to your community, that is a conversation you're going to have with your legal counsel. Another restriction effective July 1st. The association cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker solely because the worker or contractor is not on a preferred vendor list of the association. You also cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker who does not have a professional or an occupational license. All right, we're about an hour and 30 minutes in. We're going to talk about budgets and reserves quickly. Okay, every year you have to prepare an annual budget, right, of your estimated revenues and expenses. Now, your budget is going to have an operating section, right, where you list all your operating expenses. And then you might have another section that is for reserves, and we'll talk about reserves momentarily. Okay, but in terms of operating expenses, these relate to your day-to-day operations. And I've included here some examples of operating expenses you might have, and you might certainly have way more than this. But essentially your administrative, your management fees, any maintenance and repair to your common areas, taxes, insurance, certainly any professional fees. If you have an accountant or legal counsel, you'll include that in your operating section. Now, reserves. Many associations might include a line item on their operating budget called the reserves. Reserves has a specific meaning in Florida statute. And so unless these reserves are created in this fashion, you really shouldn't call reserves what you would be referring to, a contingency fund or an emergency fund, right? Statutory reserves, let's see here. Statutory reserves are specifically created under Florida statute by a vote of the owners. Okay. So typically it will require a vote of the majority of the voting interest in order to create statutory reserves. So you'd have to look at your governing doc or your official records to see if there is a record at some point where the owners voted to establish statutory reserves. If owners created statutory reserves, or if the developer created statutory reserves, then these reserves are restricted and can only be, or they must be maintained and can only be used in accordance with Florida statute. If what you call reserves, you mean discretionary funding in case of an emergency or in case there's a hurricane or whatnot, and that line item was not created by the membership or the developer, then there are not statutory reserves. They're really operating funds, in which case you can use those operating funds for any bona fide association expense. Statutory reserves, okay, they have to be calculated in a certain way. And typically you will have a reserve study specialist to come into your common areas, evaluate your common areas, your pool, your clubhouse, your tennis courts, and then provide you with a schedule of what is the remaining useful life of these assets and what is the replacement cost of these assets at the end of the useful life. And then the reserve schedule is going to tell you how much you have to fund each year so that at the end of that useful life, you have enough funds to replace these items. Now, with statutory reserves, right, if they've been properly created, they have to be used for the specific purpose for which they are established. So if you've created statutory reserves for your clubhouse roof, they can only be used to replace the clubhouse roof. They cannot be used to resurface your pool or repave the parking area of your clubhouse, unless, of course, you get a vote of the members. So they're very restricted, and you can only use reserve funds for alternate purposes if you get a vote of the membership. You also have to fund these reserves every year. Let's see here. In this slide, you have to fund these reserves every year in accordance with this reserve schedule, unless owners vote to waive or owners vote to partially fund reserves. Okay, but that's a membership vote that you need to obtain. Whether or not you want to give owners the option to waive reserves at any given year or to partially fund reserves instead of fully funding reserves for a given year, that's a business decision of the board. But remember, you have to fully fund these statutory reserves unless the owners waive or vote to partially fund. Now, if you are in this situation where you have these statutory reserves, you can terminate them. But you need a vote of the owners, and you need a vote of the majority of the total voting interest to terminate these statutory reserves and then make these funds operating funds. That's as far as I'm going to talk about these statutory reserves, because for most communities in Florida, you most likely do not have statutory reserves. If you have any questions, then I recommend you speak with your legal counsel. Now, in terms of adopting the budget, there's not much requirement in the Florida statute for the process of adopting the budget, at least not as strict as for condominiums. So essentially, unless your governing documents provide for a specific notice requirement for your budget meeting, you're going to essentially post notice of your budget meeting at least 48 hours prior to the meeting. And that's the meeting at which you're going to adopt your budget. There is no requirement to provide a copy of the budget to the owners in advance of the meeting. Okay, but then once you do adopt the budget, you do have to provide owners with a copy of the budget. And then again, as of January 1st, the association with 100 or more parcels now has to also post a copy of the annual budget on the website. All right, quickly on assessments and foreclosures. The statute gives you the ability to assess, and you likely also have that authority in your governing documents. Now, you have the ability to adopt special assessments, right? If you don't have enough funds in your budget for certain projects, right? Or in case of emergencies. Now, the statute specifically says that if you're going to adopt a special assessment, then notice of the board meeting at which you can adopt that special assessment has to be provided to the owners at least 14 days prior to the meeting. Now, if your documents provide for a longer notice requirement, you go with that. Otherwise, it's at least a 14-day notice that you have to provide. Now, the notice also needs to include a statement that a special assessment is being considered, the nature of the assessment, and you should also identify the estimated cost of the assessment on that notice. Now, once you adopt the special assessment at a duly noticed board meeting, you need to provide owners with a notice after the fact, letting them know, hey, the board adopted a special assessment on this date, and this is your portion of the special assessment. So make sure that your minutes reflect the terms of the special assessment. When are payments going to be due? Is there a lump sum payment, or can the owners pay within a certain time period? Okay, this is a bizarre law that took effect July 1st, but essentially an owner can request the association to provide a detailed accounting of any amounts that he or she owes to the association. And if the owner makes that request, the association has to provide that information within 15 business days of receipt of the written request. An owner only gets to do this once every 90 calendar days, okay? But now the penalty for the board, for the association not providing this information within the 15 business days, right, constitutes a complete waiver of any outstanding fines of the person who requested the accounting, which is more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fine. So hopefully, we'll talk about fining momentarily. Hopefully you have followed the fining process, and you're not in this position. Okay, collection of assessments. Assessments which are not paid, whether it's regular or special assessments, they bear interest at the rate that's provided in the declaration or in the bylaws. So check your bylaws or the declaration. Some of the older documents, it might include an interest rate that is much lower than what is currently provided in the statute, which is 18%. So if your documents provide, for 10%, 15%, that is the interest that you can collect. You cannot collect the 18%. If no interest, if no rate is provided in your documents, then you can collect at 18%. What we typically recommend, if you have some of the older documents, amend your documents to give the board the authority to charge interest at the highest rate permitted by law as amended from time to time. This way, if the rate changes, well, you'll automatically adapt to the higher rate without having to amend your documents in the future. Late fees, you can only charge late fees on delinquent assessments if your documents allow it. You have to have express language in your documents authorizing that. Okay. And then if you do, then the late fee cannot exceed the greater of $25 or 5% of the amount of each installment. And then you certainly are entitled to recover attorney's fees and costs in your collection foreclosure process. If an owner is delinquent and the owner pays the assessments, right, cuts a check, the statute says how you have to apply the payment. And it specifically requires that the payment be first applied to interest, then to late fees, and then to any costs and attorney's fees incurred in the collection matter, and then at the end towards the delinquent assessments. Now, notice of late assessment, if you have any owner that is delinquent and you want to turn that over to collections, to your attorney's office, the statute says that you first have to send a notice of late assessment, or NOLA, before you can refer that to the attorney, because the association cannot recover attorney's fees in the collection matter unless this letter is first sent by the association. So typically your property manager should be able to do this. And the statute provides really what the form should even look like. And it essentially gives owners an opportunity to pay. You give them 30 days to pay before you turn the matter to collections. And then you have to identify the amounts of the delinquency, the dates of the delinquency, right? So make sure that you get with your management company and follow the statutory process for the NOLA. Once you turn over your collection, your delinquent owner to collections, well, your legal counsel also has statutory deadlines that he or she has to comply before they can record a claim of lien or pursue collection. So there's a 45-day notice of intent to lien letter that has to be sent before you can file a claim of lien. And then there is a 45-day notice of intent to foreclose before you can pursue foreclosure. So these are more of the requirements your legal counsel will have to follow, but just so you're aware of what the notice timeframes are. The liability of a first mortgagee. So if a mortgagee forecloses and takes title to a parcel in your community, just know that they are limited to what they are required to pay the association. They're only responsible for the lesser of the unpaid assessments that accrue during the 12 months immediately before taking title, or 1% of the mortgage note. Now, be aware that if your governing documents specifically say that a mortgagee that takes title through foreclosure owes nothing to the association, then lenders, mortgagees have used that provision to successfully get out of the obligation to pay. So if you have older documents that say that, I would encourage you to speak with your legal counsel about amending that language out of your document so that any mortgagee is liable for the minimum amount authorized under the statute. All right, there's also financial reports that the association has to file every year. You have to prepare, or you have to have your accountant prepare a financial report of your preceding fiscal year activities within 90 days after the end of your fiscal year, or annually on the date provided in the bylaws. So check with your bylaws what your fiscal year is. Okay, and it's within 90 days that you have to prepare this financial report. And then within 21 days after the report is completed, but certainly no later than 120 days after the end of the fiscal year, the board has to provide either a copy of the financial report to all the members, or you have to provide them with written notice indicating that the financial report has been prepared and it will be made available free of charge to an owner if the owner requests. Now, the level of financial reporting will depend on the total annual revenue of the association. Unless, of course, your bylaws specifically require you to do an audit. If your bylaws require you to do an audit, you have to do a financial audit regardless of what your annual revenue is. Otherwise, you default to the statute. So for example, if your annual revenue is between 300,000 but less than 500,000, you have to only prepare a reviewed financial statement, and hopefully you have a CPA that will assist you with that. If your annual revenue is $500,000 or more, then under the statute, you have to do a financial audit. Now, as of July 1st, regardless of the association's total annual revenue, an association with at least 1,000 parcels has to prepare audited financial statements. Now, I'm not really going to talk about this here, but just be aware that the membership can vote to either raise the level of financial reporting, or, as I indicated on this slide, they can vote to lower the level of financial reporting. It does require a membership vote. Now, effective July 1st, this last bullet point, an association cannot prepare financial statements at a lower reporting level for consecutive fiscal years. So if you do get a membership vote to lower your financial reporting requirement, you just can't do it for consecutive fiscal years. And then for those associations that do have statutory reserves, right, and you've given owners the option to waive those reserves or to only partially fund those reserves in any given year, just be aware that you have to include these disclosures on your budget so that they are aware that they're waiving reserves, right, and could be subject to special assessments. Okay. Not going to spend a lot of time in contracts. The next few slides, just gave you here some practical tips for contracts. Make sure they're in writing. Make sure that they accurately reflect the terms, the desire of the board. Strongly recommend that you have your legal counsel review your contracts before you sign them. Just also be aware that if the aggregate cost of the contract is more than 10% of the annual budget, including reserves, statutory reserves, the association has to obtain competitive bids. Okay, you're not required to obtain the lowest bid, and you're not required to obtain bids during emergencies. There are certain types of contracts that are exempt from bidding requirement, which I've listed them here. So you do not need to obtain bids for these types of contracts. All right, estoppel certificates. There are a lot of slides on these on estoppel certificates. Just want you to be aware, estoppel certificates will come into play if there is a homeowner in your community that is looking to sell their parcel. Okay. If the owner will be selling their parcel, what typically happens is the title company will notify the association and request that the association respond to a questionnaire, what is called this estoppel certificate, right? And provide certain information regarding the parcel, you know, how much assessments are in the community, when are assessments typically paid. Does the owner owe any assessments? Right, I've here provided a sample of the information that an estoppel certificate might request. If the owner owes any assessments to the association, or if the owner is in violation of any governing covenants or rules, you want to make sure you identify it in this estoppel request. Because if you don't, and the unit sells, then the association could be in a position where you would have waived the ability to then go after the new owner to collect these delinquent assessments or to correct this violation. Okay. And if you do include the delinquent sums in this estoppel certificate, well, you should be getting paid at closing. Here's additional information that might be asked on the estoppel. Now, note that the association can charge for responding to these estoppel requests, and I've put here the current rates that you can charge. So the association can charge a sum not exceeding $250 if the owner is not delinquent. If the owner is delinquent, then you can charge an additional $150 on top of the $250 to respond to the estoppel. Now, the estoppel, I neglected to mention that the estoppel has to be responded to within 10 business days of receiving the request. But if, for example, the requesting party is asking you to expedite the response, you have to respond within 3 business days, and you can also charge an additional fee of $100. Okay. So the estoppel, now the estoppel certificates, the responses are also good for a certain period of time. So for example, if the estoppel certificate is delivered by hand or by email, it's good for 30 days. If the estoppel certificate is delivered by mail, then it's only good for 35 days. Okay. All right. Let's quickly move on to covenant enforcement. We're almost at the 2-hour mark. So with covenant enforcement, this is where you will be dealing with violations, right? And I've listed here, some violations common to most communities, for example, violations of your architectural standards, violations of your pet leasing or parking restrictions. Certainly you can have, nuisance conduct. So typically with a violation, the first thing you might do is have your management send a violation letter to the owner, identifying what the violation is, and then giving a reasonable opportunity for the owner to comply. Now, what happens when the owner does not comply, right? Well, you have certain remedies, right? And one of them is fining. So we'll talk about fining, suspension of use rights, suspension of voting rights. And then if all that fails, if you even pursue those remedies, or as an alternative remedy, you also have the ability to pursue legal action to force compliance, right? And then we'll talk about pre-suit mediation. All right, so quickly with fining and suspension of use rights. And this is in connection with a violation of the governing documents, has nothing to do with being delinquent. Okay, so if the owner is in violation of, let's say, your pet restriction, you have the ability to fine, right? Not really going to talk about the in detail the fining process, but essentially the board has to adopt the fine first. The fine, however, cannot be imposed until you have a committee hearing, right? At which the committee is going to get together to either confirm or deny the fine. And that committee hearing, notice of that committee hearing has to be sent to the violator at least 14 days prior to the meeting. So you'll notify the violator of the date, time, and then the location of where this hearing is going to take place. A new change in the statute that took effect July 1st is that the hearing now has to be held within 90 days after issuance of the hearing notice. So the notice has to be sent out at least 14 days prior, but the hearing now has to take place within 90 days. Now, the committee cannot be an officer, cannot be a director or an employee of the association, or the spouse, parent, child, or sibling of the officer, director, or employee. So I recognize that for most communities, for some communities, this might not be a viable option, and that's okay. This is just one of many other remedies that you can pursue. Now, the role of the committee is really limited to a yes or no vote. The committee is not going to be negotiating the fine, right? The committee's role is to either confirm the fine that's been already adopted by the board or deny the fine. And only if the committee approves the fine can it go into effect. If the committee votes down the fine or the suspension, then it cannot be imposed. And then within 7 days after the hearing, the association must now mail or email written notice to the violator, letting them know of the committee's findings, and then how the violation can be cured, if applicable. Now, if the violation has been cured before the hearing, or in the manner that's specified in the hearing notice, or in the notice of the committee's findings, then the fine cannot be imposed. If a violation is not cured, and the fine levied by the board is approved by the committee, then the committee has to set the date by which the fine has to be paid, and that date has to be at least 30 days after the delivery of the notice of the committee's findings. Now, in terms of the fine cannot exceed $100 per violation, unless, of course, your documents provide for a greater amount. And then for each day that this violation continues, right? You can charge up to $100, but not to exceed $1,000 per violation. Now, a fine of $1,000 may become a lien if your declaration specifically authorizes recovering the fine as a lien through a special assessment. You have to have specific language authorizing that. Now, with regard to suspension of use rights, the suspension would apply to common facilities to which the association has the ability to control access. So if you can control access to your pool, your tennis courts, your clubhouse through a fob system, and you have the ability to deactivate that fob, then this could be a useful tool. Otherwise, this might not be a viable option for you. But the suspension would apply only to these common facilities. It cannot, it would not apply to prohibit an owner from having any access to the property, to the lot. So you cannot prevent an owner from going to or out of his lot or the community. You can't prevent the owner from parking. Okay. And the suspension would apply to the member and when appropriate as well to the member's tenants, guests, and invitees. Now, effective July 1st, the statute was amended to now say that you cannot levy a fine for the following. You cannot levy a fine for leaving garbage cans on the curb or on the driveway within 24 hours before or after the designated garbage pickup day. And you cannot impose a fine for leaving holiday decorations or lights on the parcel unless the decorations are left for longer than 1 week after the association provides written notice to of the violation to the parcel owner. Now, you also have the ability to suspend use rights to common facilities if the owner is more than 90 days delinquent on a monetary obligation to the association. Now, monetary obligation, again, can include assessments, late fees, interest, attorney's fees, fines. If you do want to suspend the owner's ability to access common facilities due to delinquency, well, that does not require a separate committee hearing. That just requires a board vote at a duly noticed board meeting. Okay, and then the suspension would end as soon as the delinquency is paid. The association also has the option to suspend voting rights if the owner is more than 90 days delinquent. Now, the statute includes this authority, but there was recent case law that came out that essentially stood for the proposition that in order to suspend voting rights, you need to either have express authority in your governing documents, in your declaration specifically, or you needed to have Kaufman language. So in an abundance of caution, if you want to have the ability to suspend voting rights, then amend your documents. Now, if you do suspend voting rights at a duly noticed board meeting, then essentially the voting interest for the parcel is not counted towards the total number of voting interest required to approve a specific action and would not count towards quorum. So let's say you have 100 parcels in your community and you have suspended the voting rights of 10 owners. Okay, presuming you do this correctly, what that means is that if you need to establish quorum at the membership meeting and quorum is 30%, you would count quorum based on 30% of the 90 lots, not 30% of the 100. And let's say if amendments to your governing documents require a vote of the majority of all the owners, well, you would count the majority based on the 90, not of 100, if you've suspended voting rights. Okay, and then lastly, if if you've, tried all these other remedies and that didn't really force compliance, or if in the alternative, you can't really suspend use rights or fine because you just can't get the volunteers, you always have the option and the available remedy of pursuing legal action against the owner to force compliance. Now, under the statute, certain types of violations or certain types of disputes do require pre-suit mediation. That means you have to go before a mediator to try to resolve the dispute before the association can file legal action in court. And a mediation is essentially a process by which the two parties come together and they meet with a neutral third party. And the role of the mediator is really try to resolve the dispute and have the parties come to some kind of agreement. Okay, now I've listed here the types of disputes that are subject to pre-suit mediation and those that are not. Covenant enforcement is one of those disputes that is subject to pre-suit mediation. Now, I've outlined here sort of the process of pre-suit mediation. Essentially, the association has to send a certified letter to the violator requiring the violator to pick a mediator, and then you have to mediate within a certain time frame. And if the violator doesn't respond, or you do end up mediating but you don't reach an agreement, then essentially the association can pursue the a legal action against the owner to force compliance. And then the last slide, I just want to bring to your attention the self-help remedy, and then we're done. And the self-help remedy is essentially if an owner, let's say an owner fails to maintain the property, and you have language in your documents that authorizes you to go onto the property to address the owner's violation, that constitutes a self-help. And then depending on whether or not you have specific authority or not, you might even be able to charge the owner for the cost that you incurred in addressing the violation, and then recover it as a special assessment and then a lien if necessary. Well, just be aware that if you do have self-help remedy in your governing documents, the law now requires that you at least try to exercise that. In other words, you have to actually show up at the house and try to mow the owner's lawn, which he hasn't mowed for the last 3 months, okay, before you can pursue legal action in court. If you pursue legal action in court without exercising self-help remedy, presuming you have it, then the court will stop the action and then force you to exercise self-help remedy. So just be aware of that. Okay, I think I went a little bit over the 2 hours, but that is about it. I'm noticing that there's some sort of incomplete statements or incomplete questions. So folks, if you're typing in, just make sure you put in a complete thought. You can't answer any question if it's incomplete. Okay, what is defined as a commercial vehicle? Well, the statute defines a commercial vehicle, among other things, one that a vehicle that weighs 26,001 pounds. So that is the technical definition under the statute. Is it only members meetings or all meetings that require 14-day notice? Well, remember, there's membership meetings and then there's board of directors meeting. Membership meetings, unless your bylaws provide something else, require at least 14-day notice. Board of directors meetings typically require 48 posted notice unless your bylaws say something else. And then certainly if you're going to adopt a special assessment or if you're going to adopt a rule concerning parcel use, that requires a 14-day notice. All right, on quorum, if you have a 5-person board, you have 3 vacancies. So would quorum be based off 2 in attendance? No. If you have a 5-member board, quorum would be 3 out of 5. So if you only have 2 directors that are seated, then you need a 3rd person to constitute a quorum. Okay, so that should be the first agenda that you should be pursuing. we held an annual meeting, but we didn't need an election as the same board was staying in place. We didn't get a quorum of the owners. Is this still considered an annual meeting? Well, I mean, if you didn't have quorum and you didn't have an election, then you couldn't have conducted your annual meeting. So that's it. I mean, you don't need to renotice and try to get quorum. That was the one attempt at your annual meeting. All right, legal question. At an annual members meeting, does a 30% quorum include the directors on the board who are also member owners? I mean, yes. 30% includes you know, any director on the board if a director is an owner. Let's see. Is a homeowner eligible to vote if he or she is delinquent? Well, if an owner, I just talked about this, if an owner is delinquent, technically they're still entitled to vote unless the board votes to suspend voting rights, right? And that's presuming you even have the authority to do so. But the board needs to take action at a board meeting to suspend voting rights. Otherwise, the delinquent owner can continue voting.
Kerstin, here's an interesting question. Can any action be taken to the owner or resist in any way in regards to records request? I always emphasize this, Kerstin, a lot because again, the records belong to the owners, right? The membership. And you mentioned this, you know, it doesn't belong to the management. It doesn't belong to the attorney. However, we always recommend having the attorney, you know, work in collaboration with the association's legal counsel to make sure what we're delivering is the correct information. So I don't know if you want to emphasize a little bit about that, because sometimes they're like, oh, I want to see the invoices for the attorneys, right? And, you know, sometimes that information is very privileged. So records requests, you can be annoyed, you could receive as many. However, there's always options and policies that you could work with legal counsel and the board to, again, make it easy for the delivery of the information. I don't know if you want to chime in, Kerstin, but I think that's a very, very real question that we experience very often.
What was the question exactly?
The question exactly about records requests. Can any action be taken to the owner or resist in any way? So if you have an owner constantly asking for records requests, and you know, and obviously in the, you know, who's asking the question, it can be annoying, and it does cause a burden in the administration. You know, can any action be taken to the owner or resist in any way?
Well, you're not going to sue the owner, right? Like for
No, of
annoyance.
course not.
That's retaliation. But remember we talked about how the statute allows the board to adopt reasonable rules regarding the frequency and the manner of records inspection. So you can limit the number of times that an owner seeks to inspect records within a certain time period. Remember, one of the things that you can't do is limit their inspection to less than 8 business hours a month. So you can't say no more than 2 records inspections a month. You know, as a way to control this particular individual. But remember, ultimately, the owner is going to have to file a lawsuit against the association to recover those damages. Not that you want to be in that position, but there is that extra hurdle. It's not as easy in HOAs as it is for condominiums. A condominium owner can always file a division complaint, and it's very easy to do and inexpensive. So just keep that in mind. Let's see here.
And while Kerstin's looking at it and Maureen are looking at the questions, I do want to mention, yes, the slides are available. After you submit your evaluation, the confirmation screen, which I'll go over in a little bit once again when the ladies are through, has one of the bullet points, a link to download and to save the slides. Back to you both.
Let's see. if you preserve your documents at a duly called board meeting, does this have to be done in another 30 years? Yes. So you do have to preserve every 30 years. It's not a complicated process, and it's certainly a much cheaper process than revitalizing. So definitely make sure you're on it. Let's see, maybe one or two more.
Yeah, just do a couple more. And while you're looking, a couple of people texted me on the side. When the words parcels are used, that's pretty much equivalent to how many homes are in the community. So just keep in mind parcels kind of equals homes.
Yes, Kerstin, here's another great question, I think, and obviously it's, understanding the entities. How does the HOA vet new board members? Does the management company normally do this? No, management companies do not vet board members.
Come on, Maureen, you do
It's a
everything. You
good
do it
question.
all. Let's go. Come on.
Typically, I mean, if you're in a community that requires buyers to go through an approval process, that is a way to vet them at that point. But there's really no, like, the statute doesn't really address the actual vetting. It just says that the candidate has to can't be delinquent, and it can't be a convicted felon, right? I suppose it would be on the association if you want to then adopt some kind of policy requiring an owner to submit to some kind of criminal background check, before nominating themselves to the board. That's certainly an option.
Yeah, and I've seen also, candidates night. Sometimes they adopt policies to do candidates night. That way, those who want to run for the board can go ahead and have, their introduction to the community. But normally, I know management, again, we're there to serve the community. But yes, we don't normally vet the board members. That's not our position. It's the owners.
All right, two more questions. This one is a very important question. What is the cost of the slides? Okay, these slides will be provided to you free of charge. So
that was our chance. That was our chance to pay off that car. Come on.
This is done as a courtesy. We spend a lot of hours doing this to educate you guys. So free of charge. And then there's another question that I've seen a couple of times. What is the difference between majority and plurality for election purposes? Plurality votes means that, out of, if there's 3 candidates, right, and there's 100 homes, it's whoever gets the most votes. So if only 30 people voted for 3 candidates, it's whoever got the most out of those 30 votes. Okay, that's typically what is required for an election, as opposed to a majority. A majority means 50% plus 1 of the number of lots in your community. Okay, all right, that's it. That's all the time I have for today. I could sit here forever, of course.
You mean you a little busy or something? Now, come on. So, no, but thank you both, ladies. And Maureen, thank you so much for having us and collaborating with us. And before we head out, I am going to hang out after what happens next to go over the evaluation one more time. But Maureen and Kerstin, Maureen, you go first. What is the best way to get in touch with you, and any parting words you might have?
Absolutely. My email, mreyes@acam.com, my cell phone number, and I have a Zoom number. You have that information. So it's 786-559-8113. More than happy to be an added resource to your communities. If you need me to go ahead and do some free consulting, educate, whatever you need, I'm here for you. I've been in the field for quite some time. So yes, I think the easiest way, or my cell phone, my email, and you can follow me in LinkedIn as well.
Thank you. And Kerstin?
Yes, I mean, I can be reached by just calling the main office, which is 954-928-0680. With today's technology, reception will just click a button and put you through the line on my Tampa office. So, and then my email, I don't think it's there. It's Kaye Henze, HENZE @kbrlegal.com.